to settle this NAR versus the plaintiffs in the Ketchmark case, and NAR offered $418,000.
Mm-hmm.
How do you compare the $418,000 payment to the amount that was initially
$1.7 billion in damages, which when it's troubled, it's $5.3 billion, and now they're making an offer of $413. So.
Right. I'm loving that you said make an offer, because it's an offer. And let's be real, the plaintiff accepted it. And why do you think they accepted that paltry sum with 90% off?
Well, I think that right now they are just looking to change the policy. You know, my bigger issue with this whole thing is watching the reaction of all of the real estate agents on Facebook and social media, you know, Instagram, everywhere, you know, and they're all jumping up and down saying, well, we can't put buyer compensation in the MLS, so we're going to put it somewhere else. And I think everyone's missing the point here. This isn't about putting it somewhere else. It's not about taking it out of the MLS, space. It's about not including the buyer commission in someone else's contract. You know, so I think that's really what this is really about. You know, the whole lawsuit was about hiding a commission in someone else's contract. So the listing agent goes out, takes a listing, and then hides the buyer commission in that contract without even knowing who the buyer agent is going to be.
Mm-hmm. You know, and that's called decoupling, right? So that's the decoupling. So
it's uncoupled or decoupled, whatever you want to say. They do not want the two commissions in one agreement. They want separate agreements. If you represent the seller, then your commission is in the listing agreement. If you represent the buyer, your commission is between you as a buyer agent and the buyer. Not, I'm going to put it somewhere else and still let the seller pay, and I'm going to put it in showing time, or I'm going to put it something. I think
some secret code.
Some of these secret codes.
There's a secret code, secret handshake. But I'll tell you what, that, you know, over the weekend I was troubled because I thought, wait a minute, am I wrong? Because in the MLS, I was wondering whether the agreement or the proposed agreement was too strict and saying in the MLS, that could include the agent remarks. And I really couldn't understand, the no pun intended, the coupling between, I mean, how, if we can't put an MLS, and that's the kind of language that we speak, that's where we're formally, all our members were bound to be, to use the MLS, you had to be part of the board of realtors. Mm-hmm. I was wondering that, but really what you said was enlightening to me, where it all starts at the kitchen table, an agreement. And that agreement between this listing agent and the seller can have any reference. I'm going to use the attorney phrase, incorporation by reference. So there's a reference to, that's where it starts. That's where it begins, that's an end. So it can't start there. And then if it is in there, you can't, I think agents are thinking, oh, there won't be a field, so I can't put in the field with my fingers. I can like somehow let them know.
Somewhere else. It's not about hiding the commission. You know, Ketchmark said he doesn't dislike real estate agents. He dislikes the fact that we're putting two commissions in one contract that should be separated.
Because that really maintains. I mean, he was looking for the dismantling of NAR, not because they're bad people. And who cares if they are bad people or who doesn't like them? The issue is that this is where it comes from. You know, the fish rots from the head. So if NAR required boards to require membership to use the MLS, he said that's why we want that gone. That we want that offer compensation gone, because it's reflective of the agreement. So that's what always I was thinking, wait a minute, they could not have written this narrowly, like, oh, that you can't use this MLS, but you could use, I hear other people, showing time, or that's just a service for people that don't know, or a secret text. But, you know, ironically, a secret text is okay.
Call the listing agent and find out if the seller is paying.
Right.
The whole thing, they're missing the point. It's not about that. It's about separating the two. And here's the thing. I'm not, you know, against any of this either. You know, if you're a really great real estate agent, why are you wanting to hide your commission anyway? If you're so good at what you do, sit down with your client and explain your value, or as you say,
prove your competency. Prove your competency. I like that. Christine Smith said that.
And say, this is my fee, this is what I do, and you, buyer, will owe me, buyer agent, this amount of money. I don't care what the seller pays the listing agent, and the seller shouldn't care, or the listing agent shouldn't care what our agreement is. It should be completely separate.
Mm-hmm.
And Catchmark said, I do not hate real estate agents. I hate the system that you're using. So
And
why
who cares about the system? The issue is that of a compulsory mandatory nature. That's the only thing here. Because it was compulsory and mandatory for the offer of compensation to be, it must exist. That's why the $1 or 1% concept won't and can't work, because there's still an opportunity to go from $1 to $10,000, where it could be still used as steering.
Paying, and then that opens up that conversation. Just get rid of it. Buyer to buyer, buyer agent to buyer, seller to listing agent. That is what everyone is looking for.
So really what they're saying is that
DOJ
there has to be,
to protect the public.
there really has to be, let's get really close. There cannot be any transmission or conveyance of that information of a compulsory nature. It's always could be an offer, leave the couch, fix the roof, leave the blinds. It can always, anything's okay. That's the irony, is everything's okay, but one thing is not. It cannot be a reference. There cannot be a conveyance of a reference of an obligation imposed. It's just voluntary. That's where we are now.
Right.
That's interesting.
And I'll tell you, there's a couple of other things too, so why, everyone is coming out saying, oh, the news is giving out fake news, commission's going to drop drastically. Commissions may drop depending on what the buyer agent is going to, charge their buyer. And, the same thing now that it's not together, it is truly a negotiation between listing agent and seller, buyer agent and buyer. So will that change pricing? It might, it may not, but that's not fake news. That's not, anyone lying. My issue here is, why are agents yelling and screaming about, we need to continue to have sellers pay us? No, you shouldn't. It should be separate. And we can do that. We can certainly do that.
Okay, so a few things are present. There's, I have a bunch of notes. We're going to cut this video up. I found offensive even the proposed settlement, where if there's two parties to any kind of lawsuit and any resulting settlement, why do they need to give advice of what is okay? Why do they NAR come out and say, we settled and you can use seller's concessions? Why are they giving advice? They didn't give advice. NAR did not give any advice before. But now they're giving advice, and the money they're offering now, they didn't offer before. And only when faced with no way to file an appeal, no way to win an appeal, no way to get an offer, was I should say a proposed settlement approved, did they come out and give advice. Why did they? Are they playing daddy still? Where, don't worry, guys, you can still offer, giving us some. The brokers. Hold on. Didn't NAR always say, oh, we don't impose a commission, but now you're proposing a way to get paid? Isn't that a little bit crazy? Why is that left to the brokers? Why did they take this paternalistic view? Never should have been done.
I can't answer what they do. I can tell you this, though. I'm really glad that you brought up the appeal and all that. I think that's where agents should be taking to the streets and yelling and screaming. That we have been saying from day one, there will not be an appeal. And everyone's been saying, oh, there'll be an appeal and we'll win. We'll turn this around. It'll take years before there's any changes. And you and I kept saying the appeal process is pretty strict. And
it's pretty burdensome, and it's always premature because we never had a decision from which or by which to appeal. Maybe the decision could have been all candy and walnuts and flowers.
I fault NAR with not coming forward in the very beginning and not saying, hey, we may not be able to appeal. We have a problem. We're going to try to figure this out together as an association. And they didn't do that. And in my opinion, they didn't do that because they were very close to membership renewal at that time. And if they would have come out and told the truth, members would not have renewed. And then right after the renewal, after everyone re-signed and paid their dues, then all of a sudden they come out and say, we want to, propose a settlement. That is where agents should be. NAR.
Okay. And even further, did you
Disservice.
notice, did you notice that this offer to settle only came at the very end of post-trial motion practice, right? So it could go down in history that NAR lost every single motion, pre-trial, within the trial, and post-trial. They are 0 for the whole motion practice, before, during, after. They asked for a new trial. They asked for a set aside the jury verdict. I cannot say I'm complete, but I know the post-trial motion practice was absolutely de rigueur, nothing special. It was, vanilla ice cream. They had no facts. So at the end, when they were exhausted and on the eve of, because we talked about May and June, there's a relationship, and this is not law school here, but it's a relationship between the period of time in which these other settlements would be approved or not, and the conclusion of the motion practice, where they're afraid that a decision would come down from the judge where it has a complete injunction, which means, let me get ahead of this, because they don't know that if an injunction came down, a termination of this process, it could have been the full boat of $5.4 billion and you're out of business today. And who's to say? Some of the commenters, I saw some big mouth Facebook commenters said, well, the goal is not to bankrupt NAR. What do you say to that?
Oh, I disagree. I mean, the DOJ and Ketchmark said, that the DOJ said that they weren't going to stop until NAR was dismantled. When the government tells you that we're not going to stop because we find your practices to be so violative that we are going to continue this until you're dismantled, I don't think they really care if you're bankrupt or not. I think they want the policy to change, and they feel that the public is being harmed because agents are putting commissions in one contract instead of uncoupling them or decoupling them and doing it separately, which is exactly what they want. So if you want to continue in this business, why would you want to continue to practice in a violative manner when you can very easily sit down and explain, what your value is and work it out between you and your client? Why are we trying to hide it somewhere else and doing this and yelling and screaming about what went wrong? I don't blame anyone. Look, I've been in this business 37 years. And did I do this? Yes, of course. We were taught to do it this way. We did not think that there was a violation here. But now we've been told this is a violation of antitrust, a violation of steering, this is a violation of price fixing. There's so many things here.
There's so many ideas. So let's try to hit them all. I mean, I'm in no order, but I have so many notes and so many issues. Okay. So people talk about the reality of this appeal. Of this settlement. Now, I always said this is a two-pronged approach. Why is a bank going, let me start over. Why do people think that a court is going to take away the voice of the jurors? I mean, there was not in this case a JNOV, jury judgment notwithstanding a verdict. That didn't happen. That can happen. Judge say, whoa, that's crazy. We're gonna find them not liable. So now the jury comes back after they're polled by the court and says, yeah, this is worth 1.78. Now this 1.78 is not a magical mystery number. It's money that was calculated by 500,000 people as to their actual damages. It's not compensatory. So these are a form of compensatory damage. It means you're getting my money back, like a lemon law. So this number of 174, whatever, is real, number one. So why does NAR think, we're members, that we're going to give you less than 10 cents on the dollar? I owe you $5,400. Would you take $418? Why would you take that? Right. So especially since there's more to go.
Right.
So number one, why do people think that a court is going to, I'm going to use the term, pick the pockets of the aggrieved party class members? One, why do you think that? And number two, why do you think that the Department of Justice is going to say, yeah, you know what, you went far enough? The DOJ has already said that the former RE/MAX and Anywhere proposed settlements were not enough. They ever said those were. I cannot say for sure that I don't know. I'm not going to say I know how close RE/MAX's and Anywhere's proposed settlement is to this one. So it's the amicus brief by one of the learned friends of the court said that those settlements, they're not good. So from a two-pronged approach, why do people think the court and the Department of Justice are okay with what happened in this bombshell?
Yeah, I can't answer that, why everyone
No one
is
can.
thinking that, and even if they did accept it, it's really not even about that. It's about changing the policy. Why are agents saying they're getting caught up on all the wrong things? Why are they saying we're not going to change our ways? It's going to be business
Right.
as
Those are
usual.
those are, I get it. They say business as usual. They're not told. I see people complain about their board, but just as a practical nuts and bolts matter,
Mhm.
people went to closing and paid commission and sued for the return of that money.
Right.
And for NAR to
There's
have
a
its
number
approved.
set in place by the jury. I totally understand what you're
So
saying.
why do people,
I
I
don't
mean,
know why
there's,
people would think that that would be acceptable. I don't know.
right, exactly. This to me, it's somewhat of a rhetorical question. And
Mhm.
why would you, these people, they used our American judicial system of a jury trial. Everyone had their day in court. And they were, I mean, if it was me, happy day, I got my money back. I don't know how it's going to work. People want to say it's $8. I don't know for sure. So there's that, then, and
Mhm.
you made a great point, which is a really great point. We were talking about the quote unquote workarounds. This is another social media word today. The workarounds. The workarounds are opposite innovations. They're not. No one's trying to innovate and say let's take our efforts in our profession and really help people. The workarounds are how can we get somehow to avoid the imposition of
How
this.
can we continue to practice in a violative manner, knowing that we're violating the law? Because the law says they want this uncoupled, and they are saying, well, agents are saying, we are not going to pay attention to that. We're going to figure out a workaround so that we can continue the practice that got us into this problem in the first place.
Yeah, I know. I love touching
That
on
doesn't
all those
make sense
points.
to me. That actually shows me that there's not really a grasp of what is going on here. We don't have to continue to violate the law. We can go ahead and do this within the guidelines that the law has set forth now and do this properly. And
Mm-hmm.
then everyone wins. No one's upset with us. We're doing the right thing. We're protecting our buyer. If we're a buyer agent, where that there's complete transparency. I don't care what you make as a listing agent. You shouldn't care what I make as a buyer agent. It should not affect either side. And then I can continue on my merry way and you can do the same.
Right.
Why is
Okay.
that?
Well, I mean, there's so many things. I mean, I've just did such, as they say, copious notes. We're talking about, I mean, have you heard that people are saying, well, there's just more disclosure, more paper here. We just have disclosure, just have people sign more
That's
paper.
another pet peeve of mine. They're saying
I know, that's why I asked.
we've always used buyer representation agreements. Why would anything change? Everyone should be using buyer representation agreements. Everyone's going out there. If you weren't a trainer before, you're a trainer now, saying, I'm going to train you on how to get a buyer representation agreement signed. It's not about the buyer representation agreement. I hate to inform everyone. It's about the compensation, so
Well,
you
you
can
said that people couldn't, agents, only a few states required, and agents were not getting buyer agency agreements signed when the seller was paying the bill. So now they're going to get them paid when the buyer's paying the bill?
Right. So if I was getting a buyer agreement signed, a buyer representation agreement was being signed, it still stated that the seller was paying me. You didn't owe me anything. And chances are the conversation went something like, hey, Scott, in the event that the seller doesn't pay X, which is what I charge, you might be responsible for this much more. Or if you go out on your own and you buy something without me, you may owe me a commission. So just don't do that. I'm going to show you everything. That's how it went down most of the time. And many agents, most agents, by the way, unless it was required by their state, were not getting that done.
And why? You tell me why. Why weren't they?
Because, they would have to explain what was going on and buyers were afraid. Well, wait a minute. Will I be responsible for any money? Wait, if you're free, I'll give you loyalty every day of the week. It's not going to cost me any money.
Buyers didn't appreciate the cost that was baked in. The perception was there was no cost with it, and still people want to retain their options of one agent in Pelham, New York, one agent in White Plains, New York, one agent in Ryan, New York. They'd like the local flavor, which is understandable. Who wouldn't like local expertise? So that's one of the flies in the ointment, that desires and needs are in fact accurate. You want someone who's really familiar with that local market. But you can't run around now and sign up with everyone. You'll owe commissions everywhere.
Right. Right. And, here's the goes to an agent using a buyer representation agreement. They all should be using a buyer representation agreement. They should have some sort of loyalty. As an agent, you work very hard. You're out there. You're showing houses. If you don't sell them a house, you've spent gas and time and
I
expertise.
get it, but I want to ask you this. I get that. We know it's involved. But so think about what just happened here. NAR as part of the term said you must use buyer agency agreements. Okay, well, they're doing that, yet states didn't require that. So is our union superseding state law? I mean, so now there could be a conflict where the union says, or a trade law organization, a lobby says you got to do this, but the state is a requirement. So think about that. It's another obligation of membership. I have to do something that's not required by law, literally not required by law.
Right, right. But my point going back to that is, if you are talking about this thinking that a buyer representation agreement is going to save you, it's not. If people had a problem signing buyer representation agreements when they did not have to pay, believe me when I tell you.
Okay, so you think that the default setting is, I mean, and I believe this, that to save money and to avoid paying something that buyers have never paid before outside closing, they won't do it unless they've been experienced and unless they've been certified in some means or coursework or trained in order how to I say loosely demonstrate the value, but prove your competency, that you are integral to the success of the home buyer. That makes sense. I mean, why wouldn't it be?
I agree with that, and I think that there are many agents that can do that very easily, but it's really about the compensation portion of it. It's not about getting someone to sign a buyer representation agreement for loyalty. It's about
It was purely about loyalty because realtors had the blanket of security. I get that. But, now you say that now you have day one, Mr. and Mrs. kind of either unscrupulous on one end of the spectrum or high hopes. You remember you told your kids, oh, you got big eyes. You're ordering a lot. You got big eyes, but your stomach's not as big. So now people say, oh, I need that house. Where do I sign? They sign it. They love it. They do it. Now it's 2.5 months. They got their mortgage. No one told them about all the oil in the tank and no one told them about the oil in the tank. No one told them about the school tax they're due. And they just either they're scammers and they lied all along, or they just don't have the amount, or they don't have enough. Where's the enforceability? I love this topic. Where's the enforceability of that agreement?
Other whole problem, because think about this for a second. The broker is really the one who
is the only one
business, right? So the broker is the only one that can go ahead and fight for that commission that is unpaid. So they had to go and pursue a lawsuit. How is that going to work? Because many agents are on very high splits and many companies now have caps. So if you're on an 80-20, if there's a $10,000 commission, the broker's only making $2,000 on that. Are they really going to spend $5,000 to get you $2,000? Or if you're on a cap and you're already capped and now you're bringing in nothing from this deal, what will happen then? So now the commission of the agent may change because there may have to be provisions put in. If there's a lawsuit, we might have to take it out of your ends. We have to do this. Are they really going to go through that trouble? I don't know. Maybe
no.
Some will,
and that's something that might be a reason, and this sounds crazy to me, where someone would join a company simply for the fact that they'll back you, because I don't think that agents are going to bat 1,000 and get every client's who signs is going to pay. I mean, there are times when with a 95 LTV where there may not be money there. And you know what? I hate to tell you, there might be people now that's on the news, they say, I'll sign anything. I'm not paying at closing. And then what? There's no lien. You're left with a breach of contract action and a normal filing fee anywhere is a bunch of hundreds of dollars. Lawyers are charging whatever their hourly rate are. I know we can't say that. We can't charge what lawyers, I mean, all across this great nation charge. It's not going to be practical to one of these companies that you walk in and get 80, 85%. That you really expect the multitude. What if 10 agents? What if, I mean, there's just not realistic. So this is an entire burden that never was contemplated. Think about this. Enforcing compensation to buyer's agent was never an issue because the rare instance where some company was not paid at a closing went to arbitration in 2 minutes and it's policed itself without lawyers and courts.
Right.
Now here we are.
No, that is going to change. So when agents are saying business as usual, nothing will change, I think they're not realizing how much really will change. Will the changes be a bigger change than they think? I think so.
But hold on, how can business ever? This is why I laugh at that, and I don't mean that to be. I mean, I really am laughing at it. When something's never done before, how could that not be usual? How could that be usual? You have to do something you never did, but that's usual.
Mm-hmm.
I mean, learning to driving a car you never did. That's usual.
Because they're putting it the perspective of the agent right now that I see on social media is we've handled changes in the past. But those changes were adding a new disclosure, or we're going to do something a little bit different. This wasn't uncoupling commissions and doing something that we've
This wasn't taking away your. Forget about the word uncoupled commissions. This eliminates your livelihood.
Could.
It does. If you, let's say it this way, it's only, I've been telling lenders, apples, oranges. If a seller isn't pay because they'd like to keep their equity, or if they're, or I mean, everyone on social media is saying that these listing agents are going to be so magnanimous and going to say, let's pay a buyer's agent. Really? They want, I mean, the seller's going to not be mad if you're spending their money needlessly, and the listing agent is going to be so gracious to pay another broker when they're like, I got this. I'll take their offer. I'll take care of you. I mean, these are fantasies. Unless a buyer's agent is able to really, really wedge themselves in a deal and make themselves indispensable to that buyer and say, listen, I'm your best interest. We were saying something before, and I was talking to Jay, our trainer and chief policymaker on this topic. Why wouldn't, let's flip the whole devil's advocate. If you're going to pay 100% of something, why not pay 102% of it? Why not pay 103, 100, any commission it may be, apples, oranges? Why wouldn't, if you want the house, you pay for it, the representation? And what if you want that man or woman? What do you think? Wow, I want to secure the best dentist. I want to secure the best any service provider. I mean, you want the best caterer for a party. Why wouldn't you? I mean, why is this foregone conclusion that people won't pay? They will, like anything else. Any luxury car, any kind of restaurant meal. Can't you have pretty much the same meal at home?
The agent that's focused on the right things and bringing the right value. That is who they will pay. Here's a really good thing that we've been talking about. But it seems that you're either screaming in the streets, yelling in concert about what's going on and saying nothing is going to change, or if you have a different opinion, you're against the industry, and that's not true.
Great point.
Industry. We are saying stop focusing on the things that really are not true. Focus on the things that will get you to stay in business, not only survive but thrive within the guidelines of the new laws, right? Well, actually, it was always the law. We just realized that we were violating.
I call the new economy within the ruling.
But there's no reason why we're not saying, hey, we can pivot and we can continue our business within the guidelines of the law. And that doesn't mean that I'm against my industry. I'm all for my industry. But we want to do it the proper way. And then everyone is happy. Then the buyers and sellers are happy. The DOJ is happy. We're happy because we don't have to worry about being named in future lawsuits. We're not hiding commissions. We're not using code words. We're not calling the seller and begging for them to pay us because the buyer didn't. Just do it the right way. If we do it the right way, everyone wins.
And look at this explosion. It was the Ides of March. Maybe they thought the NAR backstabbed them and with to Brutus. But really, this action was filed 5 years ago, and the Department of Justice started 6 years ago. Mm-hmm. There's no reason for this level of surprise. There's still people who, I give them credit. They honestly say on social media, what is this about? I'd rather that person who admits they haven't been watching, they're working too hard, and they have not been focused on the legal surroundings. That's not their job. They have brokers, they have lawyers, they have managers. They're doing their job within the fair system they know about. Other people are just making things up and making up that the cases are fake. Do we have no trust in the American system where
representatives terrible, everyone's lying? none of that is true. I mean, the attorneys that represented us were fantastic
I
legal.
mean, they're the most. I said this before. I mean, these men and women were the best of the you could possibly have. These. I mean, most decorated, most experienced. You would want them for anything you
Which
would ever want.
I find fault isn't with our attorneys. I mean, you said there's agents out there that still don't know what's going on. You know what? You think that that's an okay thing. I don't. You know what? If this is your business, you should know what's going on in your business. You may be one or two mortgage payments away from not being able to pay your bills. You know, if this is how you support
But
you.
hold on a second. Let's say some agent had their nose to the grindstone, right? Let's be using your example. Someone's been, I mean, then they bring this to their office manager, their broker. Hey, I've been noticing 2020, COVID is a week away. I've been noticing what? We've been talking about this till today.
Right.
What? I mean, it's
I don't know.
completely wrong.
As an agent, you should be aligned with a company that is pushing down the proper information to you when it has to do with your livelihood. If this is how you support yourself, you need to know what's going on. And if you hear some grumblings about it, get the real facts. Don't listen to hearsay or what somebody else is saying. Don't join and start yelling in concert about what's unfair. You know, this is the law, and we can move forward within the guidelines of the law.
But okay, here's my question. I got a few things.
But wait a minute. You asked, you talked about NAR. You said, you know, there's a lot of misconceptions and people are angry at NAR. You know, I'm not saying that we shouldn't be angry at NAR, but I think that a lot of people are angry at NAR for the wrong reason. I think NAR should have come out and told us the truth. They knew they weren't going to appeal. They knew that there was a problem, and they knew that we could have all worked together in finding this. Here's the thing. NAR mandated that we put that into the MLS listing. Otherwise, we weren't allowed to submit the listing. NAR also mandated that everyone had to be a member. If there was someone in the that wasn't a member, they would shut down the whole office. And then, you know, fast forward, not only do they not tell us that we may have a problem because membership dues was coming up, they waited until after everyone paid their membership dues. And then they said they wanted to, you know, propose a settlement. And the letter that went out said, we're doing this to protect you, protect us from following what you mandated.
Right. They said, don't worry, you're insulated from liability. And that was ridiculous because if you're a plaintiff, who you're really going after the individual agent. I mean, you want the deep pockets. And how could an individual agent ever be responsible for anything that their broker is responsible for them?
Following what the broker was mandated to do in order to be a part of the association. So you're not doing this for us. You created this problem, and now you're saying, "Oh, we're going to appeal." You know, so agents believe that. Agents, brokers, everyone believed that their association was giving them the right advice. Boards were having meetings. Their attorneys were coming out saying, wait till they appeal. You know, they knew they weren't going to appeal, and everyone believed it. And I don't fault them for that. We always the leaders of our association because the system worked in the past. Well, the system no longer works because it's been found violative. So now I have an issue with NAR for not being transparent and honest with us. So I'm not upset agents are mad at NAR. They should be mad at NAR. But I do think they should also be figuring out how to conduct business within the guidelines of the law.
That's the opportunity we have. And you know, it's not crazy. It's a principle of American business where you demonstrate you're the person for the job, you make some promises, you under-promise and over-deliver, and are paid. I mean, it's amazing that there's this outrage for payment to me from a party other than you represent. That's nowhere found in American law or jurisprudence or business.
If you're looking for payment from the other side or somebody else's contract, I would question the competency of who you are as an agent. Why do you want to hide your commission? I don't want to hide my commission.
But everything you're saying is going to be disagreed with and poo-pooed because they're going to say we're not hiding and it's on MLS. But they were really, every agent that ever worked within the system is satisfied. They were satisfied with the money.
That worked in the past, but now they have come out and said it needs to be uncoupled, and agents are saying, no,
We're not going to uncouple it. We're going to continue to do business as usual. And now we're still going to get the seller to do it. And we're going to put it somewhere else so that we don't have to go to our own buyer and get our own contract. That's the problem, Scott.
Well, yes, that's the problem if they're looking at it as a mandatory compulsory nature. However, if there are ways that that parties can agree to compensate both, listen, you could throw in the couch, you can do whatever you want. But the fact is there is a system where maybe a home buyer really feels that they need the representation, and they feel that they could structure a deal to include the realtor who's out of the deal. What buyer's agents have to realize is they're out of the deal now. They're not in business because they can't guarantee payment on it by being merely involved. Buyer's agents have to now say that they are worthy or necessary to be involved. And then when you find, so here's my question: is there even such thing as a buyer client anymore? They're not a client until they sign an agreement, and they sign an agreement and they are prepared to pay. Here's my question: is a buyer's agent ever going to, we talked about this a while ago. Oh boy, this is a real potential conflict. If I'm representing a buyer and they have really a lot of assets, do you want that client more so than the one who barely is scraping by? Are buyer's agents going to shop buyers based on their ability to pay them and violate fiduciary duty? What about that?
Right. Yeah. I mean, we really have to take a good look at the fiduciary duty anyway at that point, but that's a whole other subject. But yeah, I see that there could definitely be a conflict, and I think that's why a lot of agents are saying, well, what about the first time home buyer or the vet? They're the ones that are going to get lost in the system because they're not going to get representation. Well, number one, maybe they don't want representation. And number two, if they do want representation, why are you saying that they can't get it? Why can't you reduce your fee? But here again, we have to look at the whole picture. The whole reason that this came about was to protect the public. And the public in the past did not know what the commission was on the buyer side. Now everyone's coming out saying the commission was always negotiable. But I can tell you, having been an agent, a broker, and a corporate, executive overseeing regions and other offices, I can tell you numerous times a buyer would walk away for $1,000. For $1,000 that they couldn't come to an agreement with, and the agent did not cut their commission. And I'm not saying they had to. I'm saying if they would walk away from a house over $1,000, what makes you think that they're not going to walk away now when they sit down with you and say, hey, this is what I'm willing to pay. Will you do it at that amount? It's up to the agent to say yes or no. That's
well, the commission was always negotiable, but the part that wasn't negotiable, which everyone seems to miss, is the inclusion of a professional that doesn't represent you. That's the part. I mean, and what did we say? A friend of ours said, wait a minute, the winner at every listing appointment is the buyer agent. The buyer agent, the prospective buyer agent, was being protected at the seller's kitchen table. Think about it. You were hurting yourself as a listing agent trying to get a listing based on price when you had your best friend that you didn't know yet. You even know the person who's going to be there yet. You're fighting for someone that wasn't there.
Right.
We're protecting.
And you have no idea who the buyer agent was going to be, what type of experience they have, if they got their license last Tuesday, if they really were going to communicate with you well, not well. Like, you had no idea who was coming to the table, but their commission was already built into the listing agreement. And there's listing agents right now that are saying, I will continue to tell my sellers to pay, because if they don't, the buyer agent won't show it. Well, right there, that's a violation.
That's a violation. And
right.
that's why, I mean,
the listing agent's concerned with what the buyer agent makes. They shouldn't be.
And that's where the prejudice that Ketchmark and the Department of Justice said is that kitchen table is the ground zero of prejudice, where I am, you, Mr. Listing Agent, my prospective listing agent, are telling me I don't have a choice. I don't want that person involved in my deal. And you're saying that your board and your broker require me to involve someone we don't know yet.
That's right.
That's
and
bingo.
They're still standing behind that, even though they know that they may be named in future lawsuits, because this is the problem right there, what we just talked about. If you uncouple it and you have it separate agreement, right? Buyer agent to buyer, listing agent to seller, there's no problem. None, zero. Now, can a buyer agent say, hey, this is what we're going to do? And look, they really don't want to come out of pocket with this. They want to put this into the mortgage, and we're okay with it. We've already, figured this out. As long as the house appraises, we're going to do it this way. If you're okay with it, Mr. Seller, Mr. and Mrs. Seller, that's fine. And that's where I think, what NAR was trying to say, you can still do a seller's concession. But that shouldn't be the opening. It should be, we have a separate agreement. The buyer knows exactly what they're paying. How they choose to pay it is up to them.
Okay, and I thought that was very, very irresponsible. This is a big point, and I mentioned this, I think not to you though. I think it's extremely irresponsible for NAR to state in its offer of settlement to the plaintiff, the aggrieved parties, to tell its members how to handle their business. Listen in. They could have said, well, we're responsible. We cover it any way they want. We want to make this thing go away. We're going to pay this amount of money, right? But then they're telling its members publicly a very, very sophisticated financial arrangement. A seller's concession is not magical. It doesn't come out of the sky like the rain. It means that 4 parties, buyer, seller, broker, have to know how this works. And not only do they know if it works, they have to be prepared for its failure. So it is not a magical thing that if a buyer's going into a purchase with a seller's concession, they have to be prepared for it not to work. If it doesn't appraise and there's no agreement for the appraised value, that means the buyer, I know that the ones I've handled, the buyer is still going in. A seller's concession does not work with, hey, let's go have an inflated price by consent, not artificially. Let's inflate the price, all of us in agreement, so it's fair. And then if it doesn't work, like I'm 10,000 less, I'll take that. No, it doesn't work. That means the loan is declined and for insufficient value, and there is no deal. So they have to be prepared to proceed without it. They can't rely. There's no safety net. That's number one. So I don't think that NAR is telling those people that never did one, it can work. It's not a panacea. So number one,
has to know that they are financing that commission over a 15, 20, or 30-year loan.
Right, but that's individual, right? That's an individual thing of how to handle the best practice. But they were assuring us, hey, that little sneaky violative practice we did, the offer of compensation required and baked in all that stuff? Well, guess what? There's a workaround. And that workaround is not a magical workaround because you rely on 4 people to get on the same page, which is hard enough. Then it has to work. And what if it doesn't work? Do you think that a seller wants to say, oh yeah, well, I'm really dying to pay this buyer's broker's commission. And if it does, in my house that I love, I'm dying to move out to Florida and get out of here. I hope it appraises, because now we have, instead of a buyer, we have an appraiser who's now in our contract. And if it doesn't work, then they don't get a realtor, then I don't get a buyer. That's not real. That's the problem. They shouldn't be giving advice. They're giving advice that really stinks. Period.
A lot of things they have done wrong, and I am not really a big fan right now because I think that they have done a huge disservice to their members. But that's my opinion on this, and I think that everyone's focused on all the wrong stuff right now. And I cannot stress this enough. We are not against the industry. We're all for the industry. In fact, we're more for the industry than all of those that are out there crying and throwing tantrums, because they will get nowhere. If they learn how to protect their commission and uncouple it, it's not about a buyer representation agreement. That's only part one. It's about protecting the compensation and being transparent with your client, regardless of what the other side is doing. If that comes together later, that's a whole different thing. But in the beginning, it has to be done properly within the guidance of the law. That is the agent that will survive. That is the agent that will thrive. And those are the brokers that will stand behind the agents that do that. That's all.
Right. And I understand that, of course, buyers, another missed road is buyers agents are important. Of course, we're all important. Everyone's important. There's such a duty here. Who knows this crazy, convoluted labyrinth of steps to take: finance, bank, contracts, closing dates, moving trucks, painting. No one knows this stuff. You need a professional in your corner. There's no question about that.
But as usual, there will be